Thank you. Good afternoon, everyone, and thank you so much for having me today at this amazing event. Um, I believe my voice went through properly.
Yes.
Excellent. So I will share slides from my end, and we can take from there. Let me see. So as as I have discussed with a conference organizer on this presentation, so I would like to discuss together with all the audience on a specific issue of process of production method. We will of course get into details on this matter, but this is a specific technical matter that is of critical importance under our ongoing discussion regarding the interplay between trade and environment and climate change. So before we get into further details, so let's first look at what is the status quo of the nexus between trade and environment. Here in the presentation today, I use the word environment and climate in a interchangeable manner. So in the last couple of decades, we have witnessed significant switch in our public understanding, policy development in all parts of in the public space regarding relationship between trade, international trade, and global environment and climate campaign. So it is quite different nowadays how we look at the interlink between the two domains compared to what the same relationship was envisaged at the beginning of the multilateral trading system. So when we're going back to the GATT time, which from 1940s, right after the Second World War, the understanding about trade environment is somehow with a highlight on a competition relationship or rivalry relationship, in the sense that the more international trade will increase more damages to the environment. Of course, damages to the climate as well. And on the other hand, high domestic environment standard will frustrate trade and production, because when we look at the high standard of environment, a high environment standard refers to a higher cost of the production, and international trade is primarily based on comparative advantage theory. If your domestic cost of production is higher, it will necessarily reduce your competitiveness in the international market. So that is a regional understanding back to the 1940s between trade and environment when the GATT system was first developed. So of course, this understanding is no longer the mainstream concept nowadays. And contemporarily, we have a new policy slogan of mutual supportiveness, in the sense that more the public policymaker, as well as trade expert or environment policy expert, more and more realize that trade policy could be a critical instrument for the global environment and climate campaign. Trade policy could be used to foster the green economy transition, as well as prevent further environment and climate degradation. And on the other hand, environment and climate contribution would possibly increase the social credit of trade policies as well. So this is against general background, particularly in light of this change in public understanding on the nexus between trade and environment. We now look like how the WTO is currently deals with environment issues. As many of you might be aware, who are more familiar with the trade system or public international law, the current approach or current regulatory model at the WTO when they deal with environment matters is a exceptional based approach. So exceptional clause under international law is a very well-known practice. So basically, in public international law, in the certain agreement or conventions, there's exception clause. Those clauses are negotiated and prepared to relieve the states from treaty liability for good faith measures taken to pursue public welfare objectives. In more concrete terms, the most known example here is Article 20 of the GATT, which is general exceptional clause of trading goods. It is the main channel through which WTO members could enforce non-economic values and objectives through trade restrictions or measures with trade restrictive effect. When climate and environment are concerned, the most known exception clause is Article 20B and Article 20G, specifically concerns public health as well as exhaustible natural resources. But how it works? So under the exceptional-based approach, there are essentially two steps. The first step is the trade restrictions will be found in violation of the state's GATT commitment. It can be non-discrimination, it can be market access, so on and so forth. But this violation is claimed by the country that they enforce this violation with good faith and in pursuit of certain other public policy goals. Not only environment, climate protection, but also public health, public moral, so on and so forth. So there's a violation in the first place, and the exception clause will be used to justify such violation. That is the step 2. So in a way, under the exceptional-based approach, the trade policies and the government enforced to protect the environment and climate is not completely legal or illegal. It is not legal because it will violate certain WTO commitment of the states, but it will be legal in the sense that it is justified by Article 20. So that's how it works so far at WTO. When we discuss climate measures, environment measures, we will come into some concrete example of such measures in the next slides. So now I would like to pose a question to the audience is, do we believe nowadays is such approach remain sufficient, remain capable, particularly in light of the significantly increased priority the public have imposed on global climate and environment campaign? Does the exception-based approach at WTO and catch up this pace? Does it remain sufficient? So in these slides, we will look into how trade policies could facilitate environment and climate campaign. Here I use the term eco-trade policies. So we know trade policies. We heard about it. We heard about it every day on the media. We read it everywhere in the textbook. So most of the trade policies, mostly, are enforced and negotiated with the aim to facilitate trade, to further the market liberalization or market opening. But eco-trade policy is different. eco-trade policies are the policies and measures that are enforced with the primary aim of environment climate protection and improvement. It is not only about trade. It is the country that decide to use trade policy to improve the environment and climate. So with such primary aim of sustainability, the outcome of such trade policy is uncertain. Some might be trade disruptive, some might be trade liberalizing or facilitating. So here we have a couple of examples here. The most known example is grant and direct payment, subsidies. Many countries provide subsidies for renewable energy production, as well as for electric vehicle production. So this is subsidy to foster the production of, if you like, green products. Subsidy under WTO is always controversial. For the industry, it is good. For the economic development, for economic growth, it is good. But it also has the suspicion that subsidy might seduce unfair competition, because one of the competitors in the market receive financial support from the government. So that is one example of eco-trade policy. The second one on the list is very well known if you are following the environment discussion these days, is the carbon border adjustment mechanism that recently enforced in the European Union. So basically, this adjustment mechanism will impose extra charges. Okay, I think I should carry on. Basically, from this mechanism, we will impose extra charges on the imports into European Union to level the playing ground between European produced products and imported products. What they are adjusting? They are adjusting the different carbon pricing, the difference between the carbon price between European Union and other countries. So in countries like in China, most developing countries, the carbon emission price is relatively lower than European competitors, than European producers. So that will be that at least aim to be adjusted as border of European Union. And at the moment, it's only for a selected sectors and industry and products. So third example here for the eco-trade policy is the European Union Renewable Energy Directives. So here, probably if you look at the title, we cannot directly link to any trade restriction embedded in this directive, in this law. But this directive has been widely debated because it basically phase out the import of palm oil from Malaysia and Indonesia for the coming years. So it's in other words, the European Union Renewable Energy Directive includes an import restriction on palm oil. And of course, I assume the audience today here understand why palm oil is considered evil, because of the production method during the harvest of palm oil caused deforestation and change of land uses. We'll get back to this point later. So the last example of eco-trade policy is tariff preferences. So if you look at the first three examples, particularly the carbon border adjustment and import restriction on palm oil, you will say, okay, all the eco-trade policy are restrictive in trade. Not necessarily, because if you look at the fourth example, the tariff preferences. So in almost every free trade agreement negotiated these days, there will be a tariff preference for environmental goods, for the goods that used to build renewable energy production plant, for example. So all this for the tariff preference for environmental goods is a eco-trade policy that aims at They aimed at improve the environment climate, but also further liberalize the trade between the signatories. So what is the feature of all these eco trade policies? Most of the eco trade policies are enforced unilaterally or domestically. We don't have a WTO multilateral agreement among WTO members on border carbon border adjustment. We don't have a multilateral agreement on how to deal with palm oil. So most measures are enforced unilaterally at domestic level, and many measures, the other feature of this eco-trade process, many measures are based on the product's embedded emission during the production and process methods. So as you can see, as mentioned, palm oil is targeted because the production and the process method of production of palm oil is known to result in deforestation. So here we will have a further discussion on process production method, PPMs. I think it's a very known concept for environmental lawyers as well as trade lawyers. Apologies for my voice today. I got a terrible virus these days and have to pause from time to time to make sure I can continue the rest of our discussion. So look at the title of PPM, Process and Production Method. It's basically look at how the product is produced and how the natural resources is extracted or harvested. And this kind of different process or different production method can have significantly different impacts on the environment and climates. So, and on the other hand, in the meanwhile, more and more environmental policies enforced, for example, in India, in European Union, worldwide, more and more environmental policies are increasingly based on the differentiation of the emission footprint during the production. So we look at how the product is produced and decide this product is environmental friendly or it is not environmental friendly. Decide it is green or it's gray. Example here we can think about is the steel products. A steel products, if you look at the same fastener, the steel fastener, one is made of coal burning. The second is made of natural gas. The third one is made of hydrogen process. Which one you would consider is green? Of course, the last one. And the problem is, we look at fasteners, they are all the same. They are all the same made of steel, they are all the same function, they are all the same performance, but they are made of through different process. And it is these differences in the production method and process that grant the same products different emission footprint. That is how the PPM plays out in our discussion today. So that's under the trade context. The essential question is whether it is legal to give a different treatment of the steel products I just mentioned. So we all know the fundamentals of multilateral trading system is non-discrimination. We don't discriminate. We don't excuse me. We don't discriminate between domestic product and foreign products. We don't discriminate between foreign product from different origin, right? And here, what we're asking is, can we discriminate, or let's put it in a more positive way, can we grant different treatment to the products based on the embedded carbon emission during the production process? Can we treat the fastener better for those who made of natural gas than those made of coal burning, because the former group of fastener is greener with less emission? So this is a question we are going to have in mind in the rest of the discussion. So before we think about how we are going to going forward with PPM in the trade system. Let's first look at how the PPM has been at the multilateral trading system from the GATT to the WTO. So PPM at multilateral trading system is a lasting controversial topic since the establishment of the GATT. So during the GATT time, the first series of cases that involve PPM is the two GATT cases in the 1980s about tuna dolphin. Basically, the United States imposed a ban on the tuna that is caught in a method injured that is caught with a method injures dolphin. So the intention of United States is very clear. Is I ban the import of this such a tuna because I want to protect dolphin, right? And the tuna fish looks exactly the same, but different only lies in how the tuna was caught with dolphin protective devices or without dolphin protective devices. So it's a typical PPM discussion under the GATT. So the panel in these two cases are struggled with the product and the process. Basically, the panel was thinking the biggest problem of the panel, one of the biggest issues the panel was facing was, should we apply national treatment, non-discrimination under Article 3 of GATT, or should we apply Article 11 on quantitative restriction of GATT? As we all know, Article 3 of national treatment will have a more complicated legal test, a complicated set of legal tests, which means the United States will have more leverage to win the case. But Article 11 of quantitative restriction is flat prohibition, which gives United States very little space to argue to justify his measure. So the two panels in these two cases believe that anything related to the PPM, how the tuna was caught instead of the tuna color or the fin color of the tuna, all the measures related to the PPM should go to Article 11. It's not Article 3, it's not national treatment discussion. Because Article 3, national treatment or non-discrimination, is only look at the product itself, not look at how the product is made. I'm not saying right or wrong. I'm just I'm just repeat what has happened. So I leave it to you to have your own opinion over this conclusion. So in that two cases, the two tuna ban went to Article 11 instead of Article 3. And easily you found a violation of the GATT. And then when you remember, we talk about exception-based approach. Can we use Article 20 to justify this violation because United States enforced such a ban to protect dolphin, to protect the life of the animal? So the panel in the two cases of the GATT also exclude the possibility to recourse to Article 20 because the panel was having problem with the measure in the sense that the panel believe Article 20 is only available for measures that the effect of which do not go beyond the border. Clearly, this ban of tuna is of extraterritorial effect. It will affect the behavior of tuna fishermen in another country. So this is the problem the panel has. The panel believes Article 20 can only be used to justify the violation within the jurisdiction of importing country. So after these two cases, the GATT or the conventional wisdom is that any PPM-based trade measure is prima facie illegal under the WTO and cannot be justified under Article 20. Then, as we all know, in 1995, WTO entered into force. We start having different cases on U.S. shrimp, U.S. tuna again. And slowly, the conclusion is that the position of the WTO towards PPM has been significantly, dramatically changed. So in the first case of U.S. shrimp, which is a similar ban the shrimp import of shrimp that is caused mortality of turtle. In that case, everybody has no problem to discuss Article 20 to justify the U.S. shrimp ban. So it is a significant departure from what the GATT panel in tuna dolphin dispute has established. And later on, in another U.S. tuna case, which is with similar factual background as the GATT cases, everybody and the panel has no issues to discuss the legality of the ban under Article 1 and Article 3 of most favored nation and national treatment, basically the principle of non-discrimination. So from the early days of the WTO, which is within around 10 years after its establishment, the WTO update on PPM is that PPM-based trade restriction will be accommodated under the WTO only if it can be justified under Article 20. So that is how PPM have evolved as WTO. And the most recent case is the EU palm oil case that was concluded last year. And it basically, in the palm oil case, it demonstrated classic exceptional-based approach of WTO towards PPM, that PPM-based measures is not necessarily illegal under WTO, but they need to be able to justify under Article 20. So what is PPM in palm oil? As mentioned earlier, we don't like palm oil because the plantation and production of palm oil resulted in significant deforestation as well as land use changes. So during the production, during the PPM of palm oil, there is a significant negative impact on the climate. So that is PPM, how PPM have evolved at WTO and GATT. So why do we need to restart this discussion if we already have the jurisprudence established there? A natural response to this question is that because so far the case law does not provide us enough understanding of how PPM will play out under the WTO. There's still a lot of space and uncertainty in the case law. But there's, of course, other reasons listed here. We consider, to start with, the current exception-based model we mentioned earlier is no longer sufficient to address environmental climate concern under the WTO. The exception-based model imposes heavy burden of proof on the part of the states. Whoever want to enforce proactive trade measures, proactive environmental measures, will have to bear heavy burden proof to justify his measure at WTO. This heavy burden proof can lead to a chill effect. In other words, the countries or states, when they want to enforce proactive environmental equal trade policy, they will give a second thought, thinking, oh, I have to justify it under WTO, which is not an easy job. And fundamentally, if you look at the current world, I think you will understand that environment and climate protection is no longer an exception to international trade. It should be part of international trade, and it is a public policy with a high priority, at least equal, if not more, than trade liberalization. So that is why basically the main argument why we consider exception-based model is no longer sufficient to address environmental concerns in the trade policy, in the trade domain. So what should we do then if the exception clause is not enough? We look for new rules. But how difficult to get new rules? Vary. The making of new multilateral rules appears to be a very challenging job. We have been talking about environmental friendly environment protection, climate change effort at WTO for at least a couple of decades. And so far, we only have one concrete multilateral agreement, WTO agreement on fishery and subsidy from fisheries subsidies, which entered into force in 2022. So now we have this kind of dilemma. We're not happy with what we're having now, the exceptional clauses, and we are not able to make new rules. If we have this dilemma, what should we do? So what we propose here is the imminent, feasible, but short-term solution is to give an updated interpretation of the existing rules that is of critical importance. PPM is one of those. So that's why in a paper I'm currently working on, I promote to rekindle the PPM discussion and to provide more thorough understanding, elaborate interpretation on PPM in light of our contemporary dynamic between trade and environment. So the main question here is, first of all, whether the states could treat differently the product made through high emission PPM and those made through low emission PPM. Or put it differently, is whether these two groups of products are like products or not under the principle of non-discrimination. Having in mind the example I just gave it to everyone about the steel products, the fasteners made through coal burning, natural gas, and hydrogen process. Are they like products? Should we give more favorable treatment to those with less emission during the PPM? So in the paper I'm currently working on, I mainly look at environment-related PPM and the principle of non-discrimination. So as just mentioned, the likeness analysis, so on and so forth. So when we come to the likeness analysis, for those who are familiar with trade law, whether two products are like product we look into, we basically frame ourselves in the classic border tax adjustment framework developed since the GATT time. 4 elements I'm sure you're familiar with is physical property of the products, end users of product, consumer preferences against the product, tariff classification of the products. This is how we assess likeness under the GATT on the non-discrimination. So if we want to do the PPM, the first question to ask is whether a product's environment-related PPM can affect the consumer's preference. Would you prefer rapeseed oil to palm oil because the production of the latter generates more impact on the environment? Or would you, as a consumer, don't care? You just go for which is more favorable in terms of price and availability. So that's basically question 1. So question 2 is whether a product embedded emission during the production can be part of the physical properties. This is a tricky question. Would you consider as a consumer or as a lawyer, would you consider the steel fasteners made through coal burning and those made through hydrogen process different in physical property because they have definitely different level of emission during production? Trust me, it is a very complicated question, and some scholars even use philosophical approach to look at this aspect. So in the paper I'm currently working on, I basically argue for both a yes answer. And of course, both questions will highly dependent on the availability of scientific and market evidence. You look into market, you know how the consumer preferences will be. You look at scientific process, scientific evidence, you know how different the embedded emission would be, how different the embedded emission would be between coal burning and hydrogen process. This is mainly what I've been working focus on the PPM with non-discrimination. One example or one different discussion, slightly different discussion is the tariff, the use of tariff. So of course, everybody knows what a tariff, and tariff has been the first and foremost trade instrument you can think about as a trade lawyer. It is enforced at the border. You import a product into a country, you have to pay a tariff at the border. And that is mostly a important income of the revenue of the statement of the government, but also it can be used as a leverage of protection to protect infant industry domestically, as well as to protect its strategic products. Anyway, so here we're looking at low carbon tariff preferences based on PPM. What does that mean? So tariff, to start with, is very widely used in environment for environment and climate purpose already. As mentioned early on, the tariff preferences for environmental goods. You give very low tariff for environmental goods in free trade agreement to encourage its transaction and import and export. But here, insofar as PPM is concerned, we're looking at something different. We're looking at a low carbon tariff preference. It's a tariff preference or lower or reduced tariff for imports that utilize low carbon PPM with less environment and climate impact. Again, let's go back to the fastener case. Can we give zero tariff to fasteners made through hydrogen process and give 10% tariff for fastener made through coal burning? So bear in mind, the fastener, if you think about it, the fastener at hand are exactly the same, with the same performance, with the same character, with the same function, except how it was made. So in the paper I'm working on, this is also a interesting topic. And what I'm arguing is that this is within the state's prerogative. The states have the right to charge different tariffs in this regard. So at the practical front, what is important here is the practical concern is the data-dependent application. So it is, if you want to do tariff, you will go through customer authorities. So the concerned PPM ought to be measurable for the customer authority to have evidence to decide whether it is accurate, it is enough for this product to be characterized into a lower tariff category or higher tariff category. It has to be measurable and it has to be reliant on the available data. And this is uncertainty. This is purely uncertainty because the initiative of low carbon tariff preference is still undergoing, and we're still facing huge difficulties to digitalize information as a handling of the customer authority. So this is the two aspects where I look at PPM at the GET system. The concluding remarks are the following. The environment and climate are no longer exception to international trade. Rather, they ought to be essential part of a contemporary trade policies. And traditional exceptionalism approach is no longer able to accurately denote the contemporary nexus between trade and environment. So we need something more. PPM and clarification of its role in trade regulation could be a good case study and inspire the repositioning of sustainability goals as essential part of trade governance rather than merely exceptionally to it. So here is all my presentation of today.